Welcome to Negligence, Element 1, Duty, Video 2, Does a Duty of Care Exist? This is our common law analysis where we focus on duty and the element to determine whether or not there is liability for negligence. This is video 2. First element, duty. This video begins our discussion on element 1 of negligence, which is duty. For this video, we'll start at the beginning. For a common law analysis for negligence, step 1 had me before. I like steps. Step 1 is the test for duty. The duty test has 2 prongs. Prong 1, does the defendant owe a duty of care to the plaintiff? Prong 2, if the defendant owes a duty of care to the plaintiff, what is the standard of care that is legally required? This is our duty analysis model. This is our duty analysis model. Remember this and remember this well. If there is no duty, there is no negligence. If there is no duty, there is no negligence. Understand, the concept of duty as an element is primarily about legal relationships and whether the law recognizes an obligation for the defendant to act or refrain from acting in a particular way toward a particular plaintiff. Not every harm suffered by a plaintiff creates a legal cause of action, and not every relationship imposes a legal duty of care. Let's start with the general definition of negligence. We find that in the Restatement Second of Torts, Section 282. Conduct which falls below the expected standard established by law for the protection of others against unreasonable risk of harm is negligence. Legal, not descriptive. Legal, not descriptive. Try one more time. The Restatement Second of Torts, Section 282, defines negligence as conduct which falls below the expected standard established by law for the protection of others against unreasonable risk of harm. Implicit in this definition is the concept of duty of care, meaning that before conduct can be deemed negligent, the defendant must have a legal responsibility to act with reasonable caution under the circumstances to prevent unreasonable risk of harm to others. I know it's a mouthful, but the more that we practice this, the more that it's going to start to make sense. Now, because we have been newly introduced, let's take a moment just to reset ourselves and remember what the elements of negligence are. Duty, which means the defendant owed a legal duty of care to the plaintiff. Right? Duty has 2 prongs in order to be established. Prong 1, question 1, does the actor, defendant, owe a legal obligation to the plaintiff to not increase the risk of harm to the plaintiff? Question 2, prong 2, if the answer is yes, what is the level or the standard of care that is owed? Okay, that was all under duty, element one. Element two, breach of duty. That's where the defendant has failed to meet the required standard that's been identified under duty of care. Third element, actual cause, also known as cause and fact. That is the defendant's breach of the duty of care actually caused the plaintiff's injury. We'll use two tests, but for substantial factor once we get there. Element four, proximate cause. The harm was a foreseeable consequence of the defendant's action. That's where we're going to start talking about superseding and intervening causes. And then element five, which is damages, which is the compensable harm. So those are the elements. Just wanted to say them again so that we can become familiar with them, not for the purpose of memorizing them, but for the purpose of learning them. What is a duty of care? The term duty in tort law specifically refers to the phrase duty of care. Duty of care is a legal obligation to exercise reasonable care in your actions or omissions to avoid causing harm to others. Now, I am defining legal obligation as being legally required to do or not to do something for which your noncompliance may mean legal consequences. And I want you to kind of pay attention to the scale that we are building, because it's in the understanding of the words, right? It's the word. I keep trying to tell you all. The truth is in the word. We only have words as our tools, right? We don't get any fancy thingamajigs. It's words. They live, they matter. So I want you to lean in and embrace this language. A legal obligation is how we define duty of care. And I'm defining legal obligation as being a legal requirement. It is a legal requirement to do or not to do something. And the failure to adhere to that legal requirement to do or not do is going to, more than likely, leave you vulnerable to legal consequences. Okay, so we know what a duty is. It's a legal obligation. We know what a legal obligation is. That's a requirement to do or not to do something for which your failure to adhere will leave you vulnerable to legal liability. Well, how do you get this legal duty? How is a duty of care created? They can be created by statute. They can be created by contract of the parties. They can be created by common law principles. Ooh, that's us. And statutes. They can be created by judicial decisions. Ooh, that one's us as well. Right. So there's several ways that we get these legal obligations, right? So it's a legal obligation. Well, who gave us the legal obligation? Well, there's several ways to get there. Well, what are the ways? Here's a few: statute, contracts, common law principles, and judicial decisions. Now, do not confuse legal obligation with moral obligation. I've said it once, I'll say it again. The law and justice don't necessarily meet at the same place. Okay? Do not confuse a legal obligation with a moral obligation. Legal obligation is enforceable by law. You don't pay your taxes, you're going to be sought after. if you were supposed to, right? A moral obligation is based on ethics or personal conscience, right? And while you might not be sought after by the law, there's some spiritual consequences, but right now we're in the legal realm, okay? Only legal obligations carry enforceable consequences under the law. Here's an example. You're shopping at a grocery store. As you walk down the aisle, you see an elderly woman reach for a jar on the top shelf. The jar slips from her hands, shatters on the floor, and she falls, injuring her hip. What's the moral duty? As a decent human being, you likely feel a moral obligation to help the little lady, right? Maybe you check to see if she's okay. Maybe you ask for help. Maybe you advise her to stay still until help arrives, right? Right there. You have no legal responsibility for this person that you don't know, but your spirit reach out to her as another human being. Because we like to believe that society expects kindness and compassion, but you're not going to get cited. You're not going to get a ticket. You're not going to get fined if you just walk past, not from a secular perspective. What would a legal duty? You, as a fellow customer, have no legal duty. You didn't cause her to fall. You didn't put into action the motion that resulted in her falling. And based upon the hypothetical, which is up there in the green block, it's very small, there's nothing to indicate that you have a special relationship with her that would impose a legal duty of care, right? Now, that's you as another shopper. The store owner or the employees may have a legal duty, right? Because part of that will designate the lady as a trespasser, which she probably isn't if she's in the store shopping, a licensee, or an invitee. And as an employer or the owner of a business, you will have a higher level of care for those who are your customers. Those types of duties are called duties by owners and operators of land. Duties of owners and operators of land. That's another subcategory of standard of care. Okay, but we were talking about what your responsibility was or what your expected responsibility was as a shopper. So don't get moral duty and legal duty mixed up. They're different things. Yeah. So what is the definition of legal obligation? Because we watch the scale, watch the scale. Duty infers duty of care. I defined that to mean a legal obligation. So what's the definition of a legal obligation? A legal obligation is a requirement by law or a mandate by law that requires an individual to conform to a particular standard. Well, okay, well, let's watch the next level of the scale. What does conform mean? Because you said that, let's just back it up. What is a duty of care? Duty of care is a legal obligation. What is a legal obligation? A legal obligation is a legal requirement or a legal mandate that requires you to conform. What does conform mean? It means that it's the legal obligation or the legal mandate requires you to comply with, to adhere to, or to act in accordance with a set standard of care. Well, what's being conformed? The defendant's conduct, the defendant's actions, the defendant's behavior is being conformed to a particular standard of care. What are the particular sets of standards of care? Slow down. I almost got you because we had a roll going, didn't we? Could you feel it? Yeah. Right. Slow down. We're going to address the particular sets of standards of care when we address prong 2 of the duty analysis. And you're going to have to wait for the next video. Okay. So before we get to the prong 1 test, remember, where are we? Duty. Duty has 2 prongs. 1, is there a duty of care owed by the defendant to the plaintiff? Prong 2, if there is a duty of care owed, what is the standard of care? This video 2, is addressing how do we determine if a duty of care is owed. That's prong 1. Before we get to the test, because we're getting to the test, before we get to the prong 1 test, I want to quickly review the uniqueness of the duty element. The duty element and the duty analysis must be analyzed first. I see a little extra space that we can go ahead so that doesn't cause anybody any consternation. Excellent. The duty element must be analyzed first. The duty element has 2 prongs. If there is no duty, because that's prong 1, is there a duty that the defendant owes to the plaintiff? If there is no duty, there is no negligence. It's almost like intentional torts in the sense, if there is no intent, right, there is no intentional tort. It may be negligence, but if there's no intent, there's no intentional tort. Well, with negligence, with element 1, with duty, if there is no duty owed by the defendant to the plaintiff, there is no negligence. See why we, common law, 49 states, identify our analysis as a duty analysis, because as the threshold, if there's no duty, there's no negligence. Another unique quality of duty is that duty is judicially determined. The duty element is the only element that's decided by the judge and not the jury. Again, duty is a threshold requirement. And if we don't meet the threshold, what does that mean? That means that we don't proceed any further in the analysis. So those are some unique characteristics about the element of duty. You're not going to find those anywhere else, right, with the other elements. The judge determines duty, not the jury. Okay. Here's the test. Ready? Got your pipette going? Got your test tubes ready? Everything's labeled and numbered and ready to go. Let's go. Here is the 2-prong duty test. Duty. First, I have to determine if the defendant owes the plaintiff a duty of care. If in that determination, the answer is affirmative, yes, the defendant owes the duty of care to the plaintiff, then I'll go to the second prong of duty, which is what is the duty/standard of care? Prong 1. Prong 1 has two different approaches. Now, don't get mixed up. We're going at a pace where you can keep up and you can stop it, you can rewind it, you can fast forward it, so it's all fine. Duty has two prongs. Is there a duty? What is the duty? Is there a duty, which is prong one, has two approaches, the traditional approach, the modern approach. If you are a student of Professor Washington, we use the traditional approach. The traditional approach is the Cardozo approach that was announced in Palsgraf. 1928, Palsgraf versus Long Island Railroad. There will be a video where we go through the cases. So I'm not going to do a deep dive on Palsgraf right here because I'm trying to get through the prong one of the first element. The traditional approach is that generally there's no duty. I don't generally owe a duty to anyone. That's the traditional approach. Historically, the common law followed a general no duty rule, meaning that a person was not legally required to take affirmative action or to not act to protect another from harm unless there was some specific legal relationship or some public policy imposed, right? How was that captured in the restatement? Restatement Second of Torts, Section 314, which states, the fact that the actor realizes or should realize that action on his part is not necessary for another's aid or protection does not itself impose upon him a duty, right? It does not impose upon him a duty. There is no negligence in the air or duty in the air or duty everywhere. In Palsgraf, not doing a deep dive, just enough to give you a root, a foundation for the traditional approach from determining whether or not there's a duty. In Palsgraf, Justice Cardozo articulated a foreseeability-based duty rule. That was actually, if you remember, if you're with me this semester, if you remember, that that foreseeability-based duty rule was actually introduced in a products liability case more than 10 years before Palsgraf. Remember, that's McPherson versus Buick. But now we are in 1928, and we now have negligence on the scene. Yeah. So in his announcement, Justice Cardozo, articulating the foreseeability-based duty rule, states, a defendant is only liable for that first element of duty if the injured party was a plaintiff who was foreseeable and was within the orbit of danger. We call it zone of danger. Cardozo called it orbit of danger. That is a term of art, that if you're being asked a negligence question where you're being given the opportunity to address the issue of duty, they're looking for that language. Foreseeable plaintiffs, zone or orbit of danger, okay? Under this framework, the foreseeability-based duty rule, duty is not owed to the world at large, but only to foreseeable plaintiffs who are within the zone of foreseeability. That's traditional, that's Washington. Foreseeability. Duty is not owed to everyone. Got it? The modern approach is understandably the opposite of no general duty. The modern approach is there is a duty of reasonable care owed to everyone. Over time, the courts have begun to shift away from the strict no duty rule, instead presuming that a general duty of reasonable care exists unless a specific policy exception prevents it from existing. So you see the traditional rule, there's no duty unless it's foreseeable, because I've got a foreseeable plaintiff, not foreseeable as in proximate cause foreseeability. Be careful, don't get lazy. These terms are used in different places, and when they're used in different places, they mean different things. Don't get lazy. Don't get lazy. When Cardozo is speaking about foreseeability in the duty element, he's very specific. He's looking at potential plaintiffs. Are they foreseeable? And are they in the zone or orbit of danger? That is the limit of foreseeability as it relates to duty. When we start to speak of foreseeability as it relates to proximate cause, we are now focused on, is the harm that results foreseeable based on the actions, the conduct, the behavior of the defendant, right? So once the defendant starts the first domino, is the harm that results a foreseeable consequence? Proximity, right? Proximate cause is looking at the action of the defendant and the resulting harm. Foreseeability for duty is looking at the potential plaintiff and the zone. Don't get those mixed up. There's no reason to. If you take your time and undo the knot, it all makes sense because they all have their own place in space. Now, back to the modern approach. In the modern approach, a general duty of reasonable care is presumed. Where do I get that restatement? Restatement 3rd of torts, section 7. An actor ordinarily has a duty to exercise reasonable care when the actor's conduct creates a risk of physical harm. I tried to slow down. An actor ordinarily has a duty to exercise reasonable care when the actor's conduct creates a risk of physical harm. In exceptional cases, a court may decide that a defendant has no duty or that the ordinary duty of reasonable care should be modified. But as a general rule, in the modern approach, Restatement 3rd of torts 7, an actor ordinarily has a duty to exercise reasonable care when the actor's conduct creates a risk of physical harm. The shift moving duty away from foreseeability in this more modern approach, right, creates a broader assumption of responsibility. What does that sound like? That aligns with the dissenting opinion by Justice Andrews and Palsgraf. Remember, Justice Andrews argued that everyone owes a duty to the world at large, and that questions of liability should be determined through proximate cause rather than duty limitations. This is extremely, extremely important. If you are in my tort sections, I do not test the restatement third of torts, section 7, Justice Andrews. I test Cardoza, where duty is limited. I do not test that we have a broad duty. So what is your expectation if I ask you that question in an exam? The expectation is you talk to me about one of the 6 following tests that we're about to address, for which test number 2 is Cardoza's foreseeability. Yeah. Right now, if you're studying to take the bar exam and the bar exam has been written in common law states, the test is Cardoza. Okay. All right. Fantastic. Moving on. This is important to remember. If there is no duty, there is no negligence. So there are 6 tests that you can choose from under the traditional approach to determine whether or not a duty exists. There are 6 tests under the traditional approach. Remember, I just said that foreseeability is the second one out of 6. Now, you can use any of these 6. So what I'm saying to you when I say that Washington wants foreseeability, what I'm saying to you is Washington does not want restatement third of torts, Andrews, where everybody's owed a duty. I want the traditional approach. You have these 6 options. Most of the time, foreseeability is going to be the way to go. But there are going to be times when these other 5 are more applicable. How do you know? You're building your discernment. That's how you know. At the bottom, if a duty exists, then you're going to proceed to prong 2, which is the standard of care, which is the next video. So what are the 6 tests? I gave them to you here. Let's go through them in a little bit more detail. The reasonable person test. The reasonable person test to test for the existence of a duty. That's restatement second of torts 283. The standard of conduct to which one must conform to avoid negligence is that of a reasonable person. So when you are asking, did this person have a duty as a defendant to the plaintiff, and you choose to use the reasonable person test, what you are doing is you're asking this question: would a reasonable person in the defendant's position have acted differently to prevent the harm in the same or similar circumstances? What's the question? Would a reasonable person in the defendant's position have acted differently to prevent the harm in the same or similar circumstance? Here's an example. A driver runs a stop sign and hits a pedestrian. As the court is trying to make a decision about whether the driver had a duty of care to the plaintiff, the judge is going to ask whether a reasonable driver would have stopped, because that would have prevented the harm to the plaintiff. If the answer is yes, a reasonable person would have stopped using the reasonable person test. There's a duty, we go to prong 2. Got it? Make sense? right? Read the von Menlove. That helps you understand reasonable person being an objective standard, not an objective standard. When you're testing for duty, reasonable person is the correct answer, but it's the correct answer that more often than not, if you're my student, is going to get you the fewest points because you asked one simple question: would a reasonable person in the defendant's position have acted differently to prevent the harm to the plaintiff in the same or similar circumstance? There's not a lot of heavy lifting. So, is it a viable test? It is. Is it an appropriate test? It is. Is it a test that will get you points? It is. Is it a test that's correct? Oh, yeah. Is it a test that's going to maximize your points? It is not. Okay. All right. Perfect. Let's go to the second test. What are we doing? We are trying to determine if a duty exists from the defendant to the plaintiff. We're going to do our second test, which is our foreseeability test. Great. What's the foreseeability test? Oops. What's the foreseeability test? The foreseeability test is reduced to writing in the Restatement Second of Torts, Section 281. And Section 281, Restatement Second, says, a duty arises when the actor should recognize that their conduct involves an unreasonable risk of causing harm to another. How many times have I said to you, Washington likes the foreseeability test, right? Will Washington accept the reasonable person test? Of course, because it's still part of that traditional measure. Does Washington like the foreseeability test? She does. Ooh-wee. What is the question if I'm going to use the foreseeability test to determine whether or not a duty exists? There is not a question. There are two questions. Question number one: who is the foreseeable plaintiff? Because if there's a foreseeable plaintiff, I'm halfway to establishing that there's a duty. For foreseeability was question two. What is the zone of danger? And so for foreseeability test, not for proximity foreseeability, I'm in one. I'm in element one. I'm under duty. What is the foreseeability test? I am trying to anticipate that if I act a certain way, if I conduct myself a certain way, if I behave a certain way, who, if anyone, will be negatively impacted by that? Well, I'm looking around and I'm trying to see who could possibly sue me in a case of negligence because they were injured or harmed by my conduct, by my actions, or by my behavior. Those are my foreseeable plaintiffs. And once I've identified them, I have to identify what is the area that these plaintiffs have to be within in order to be impacted, in order to be harmed by me. That is my zone of danger. For the formative, we had a substitute security guard. Who are the people who could potentially sue the security guard for negligence? The people in the bank, the customers, the visitors, the employees, the faculty, the staff. What is the zone? How far does his impact reach? If he's negligent and pulls out his gun and takes the safety off and handles it negligently, how far can that fail standard behavior reach? Well, it's definitely going to reach the people in the bank. So where would the zone of danger be? Within the side of the bank. Does that make sense? Inside of the bank. Yeah. Okay. That's the foreseeability test. Hang in there. We're almost done. Third test, foreseeability. Oh, I'm sorry, not for foreseeability. That's why I stumbled on it. Third test to determine if a duty exists. That's the special relationships test. You want more information, go look at 314, Restatement Second of Torts 314. Are these absolutely right? There might be some better ways, right? That's your responsibility to find it. The Farwell v. Keaton case is a perfect example. In this test, we're looking at, does the law impose a duty based upon the nature of the relationship? Does the law pose a duty based upon the relationship? Well, like what? Like a doctor-patient relationship? Like a employer-employee relationship? Like a business owner to customer relationship? Like a carrier to passenger relationship? Like a innkeeper to guest relationship? Right? Does the law impose a legal obligation for the defendant to conform their action, their behavior, their conduct to a certain standard? If so, you might be able to establish that a duty exists in prong one under Restatement Second of Torts 314A. Okay. What's a public policy way to test if a duty exists? What's a public policy way to test if a duty exists? This is going to be test number 4. Well, oops, sorry. There we go. Public policy. I have here 315, and 315 really doesn't say public policy. And so it's probably not going to be your strongest reference, right? Because sometimes our references are nuanced. But what's going on with public policy? One of the best examples for a public policy argument is the Kelly v. Gwinnell case. I actually put the Tarasoff v. Regents of California, which is good, but we actually read the Kelly v. Gwinnell case. And so actually, let's go ahead. Oops. And we're going to put Kelly v. Gwinnell right there, because that is really a very good case to talk about public policy. Okay, nice. All right. Social host and dram shop. Social host and dram shop. In the Kelly v. Gwinnell case, guy comes over after work, has a couple of drinks, has a couple more drinks, being served by a gracious host who leaves, not the host, but the guest, and drives themselves home and gets into an accident. Can I pull the social host into this? You doggone better know that you can, right? But for public policy, the court in making that determination doesn't really lean on just one restatement, right? They look at foreseeability, which is the second test. They look at the public policy, which means, is there a policy reason? Is there a safety reason? Is there a welfare reason? Is there a measure of protection reason why we need to not just look at a foreseeability or not just look at a relationship, right? Is there a policy reason? Is it, we look at the issues of fairness and we look at the issues of justice. So Public policy is a test. It's the fourth test that you can use in order to establish if there's a duty. You might want to read the Gwinnell case. It's a really good case that gives a great example of what it is. Number 5, that is the control-based duty test. The control-based duty test. That's Restatement Second of Torts, Section 319. And it says, one who takes charge of a third person whom he knows or should know to be likely to cause bodily harm to others if they're not controlled is under a duty to exercise reasonable care to actually control the third person to prevent him from doing such harm. I was asked if there's an example of this, and I said, sure, there are a couple in the book, but I did put an example in the chart. A psychiatrist learns that their patient has made a credible threat of violence against an identified specific person. So your client, you are a psychiatrist, your client has made a credible threat of violence against someone specific. Not a general threat, a specific threat, not at the general population, at a specific identifiable person. Does that create a duty on you to not increase the harm of the person who's being identified as the potential victim? Which means what? That you'll pick up the phone and try to warn that person? The answer is yes. Why? Because the law sees that you have some level of control of your client. Well, as a psychiatrist, what level of control do you have? Yeah, you might need to have them committed for a short period. You might need to have them evaluated or re-evaluated, right? They're with that level of responsibility, you might have a duty to do something. For instance, similarly, the duty that a lawyer may have to warn a third person to the extent that the lawyer has charge of a person who has dangerous propensities, right? What is my duty to try to control that person? I don't know. Do I need to call the mental health deputies? Maybe. Do I need to call law enforcement? Maybe, right? When you get these jobs that have great potential for income, oftentimes you have even greater responsibility for care. So just be aware. What's the 6th test? Are these the only 6 tests? No. Are these the 6 most popular that are tested? Yes. What is the 6th test? That's the voluntary undertaking test. And that's Restatement Section of Torts 323. And of course, that one's probably pretty easy. A babysitter or a bystander offers to help a driving swimmer, but does so recklessly, causing further harm, is the uh, Good Samaritan now potentially liable? Possibly. Right, possibly. Now, some states have shield laws for Good Samaritans. Some states don't. But if this is the one that I call you broke it, you broke it, you buy it, right? You voluntarily put yourself in a position of having a duty not to increase the harm to somebody, and then you wind up increasing the harm to somebody. That could hold you potentially liable, right? That can hold you potentially liable. So those are the 6 tests that you have available to you to determine whether or not a duty is owed by the defendant to the plaintiff. That's prong 1. Does a duty exist? Under element 1, duty. If I go through one of these tests. You do not need all 6. If you're my student, you don't get extra credit for giving me all 6, right? So how do I know which one to use? And if I can use the reasonable person standard, why do I have all of these other ones anyway? Well, I have all of these other ones anyway because negligence has to have some level of flexibility, right? Even if it's something that a judge decides, there's got to be some level of flexibility. This is not a one size fits all approach. Some are more appropriate for some facts than others. When you are in practice, who's going to tell you which one to use? You're going to tell yourself. You're going to have to discern it. So if you're taking my test and I'm asking you to establish duty, you know that you've got 6 options to choose from. You pick the one that is supported by your facts. You pick the one that is the most efficient, is the most effective, and is the most appropriate under those circumstances, right? You don't get bonus points for doing easy. That is the 6th test for duty and whether it exists under prong 1. That took less than 50 minutes. I am going to post the video link once the video converts, and I will post the PowerPoint, and then we will be on to video 3, which is going to be negligence, video 3, element 1, duty, and how to determine prong 2, which is the standard of care. Thank you guys for watching. I hope this was beneficial. If it helps you, use it. If it doesn't help you, act like it never happened. Have a great one.